Okay. So with that, we'll get started. So hello, everyone. Thank you guys so much for joining. Despite the technical difficulties, again, sorry, Zoom updated some settings that we weren't aware of. But thank you guys for overcoming that and being here with us today. So my name is Hannah Roth, and I work with Predictive ROI, and I will be helping moderate the Q&A session today. So before Sharon begins, I just want to go over a few housekeeping items. So number one, if you're not already, please put yourself on mute so we don't have any distracting noises. As you guys can see, there will be quite a few people on the call today, and we want the sound to be as clear as possible for everyone.
I'm
Okay, so perfect example, thank you. So also the session is going to be recorded. So if there are questions that you would prefer to ask in private, you can email them to kayla@legalandcreative.com, and I will go ahead and put her email address into the chat right now. So if you have any private questions, feel free to email Kayla and they will get back to you. Okay, so the format for the Q&A is going to be about 20 minutes of fast-paced teaching, and then we will open up the floor for additional questions. And feel free to ask questions in the chat as we go, so you don't have to wait until the question portion of the Q&A to ask them, because odds are good we will have a ton of questions, and sometimes we can't get through everything, or we'd be here for 3 hours. So for those questions that possibly don't get answered, our goal is to reach out via email to talk about those more. Also, if you can, please turn on your videos unless you're engaged in another activity. It's more fun to talk and collaborate with people when you can see them. So that's more fun than talking to blank screen. So please turn on your video if you're able. And then finally, don't be intimidated or feel nervous about asking quote unquote dumb questions. The whole purpose of this session is to learn. And if you have the question, chances are multiple other people in the room also have a similar question. I like to remind everybody that Sharon got a law degree on purpose, so the rest of us don't have to. So please feel free to ask your questions if you have them. Okay, so that wraps up our housekeeping. So now I'm going to move into introducing you to why you're all here, which is to meet and learn from Sharon. So I've known Sharon for a few years now. And for those of you who also know Sharon, you know that she's super generous with her knowledge, which makes her an amazing resource as well as a great person to know and to work alongside. So for those of you potentially meeting for the first time, Sharon Torek is an intellectual property and marketing law attorney. She specializes in helping agencies leverage legal opportunities, so monetizing their IP, as well as protecting them from potentially costly risks. She's also a regular guest speaker for Agency Management Institute. She's the former president of the American Ad Federation of Cleveland, and she serves on the legal consultant panel for the American Association of Advertising Agencies. So Sharon regularly consults on topics of intellectual property protection, artificial intelligence, and the changing legalities that go along with that rapidly evolving industry and ecosystem. She talks about marketing agency relationships and the legal implications of social media. So for today's session, Sharon will be sharing her smarts when it comes to agency partnerships, which will be super relevant for everyone in the room. So with that, let's dive in. So Sharon.
Thanks, Hannah.
Of course.
Let me get my slide tee up here. All right. This has become one of my favorite topics to talk with agencies about. And I'll explain the reasons for that. I'd like to say to agencies on the issue of agency to agency collaboration, if it hasn't happened yet for your agency, which is becoming increasingly unlikely, it probably will very soon. So why address this topic? And why have we seen an increase? We're not quite sure, but I have a couple of theories. I think that agencies in general are collaborating with one another more now than they have in the past, because of access to perhaps specific skill sets or talent bases that they either for business reasons don't want to staff up for internally, or it's just more efficient for them to have a strategic alliance firm to work with when these things come up. Perhaps they don't come up frequently enough to actually run internally in-house in the agency. I think we're in an age of increased agency specialization, which is an approach I personally happen to be hugely in favor of in the independent agency world. I think it creates lots of opportunity. And we've also seen a overall increase in agency M&A activity, even for the smallest of firms, and usually a precursor to agencies talking about combining formally is working together in a more limited scope, such as a strategic alliance. And so I think you'll be seeing more of these. I think you're here probably because you've maybe had these opportunities or you see them in your future. I'm going to skip this part because Hannah did a great job of telling you a little bit about us. The only thing I would add to it is check out Innovative Agency Podcast. It's not a legal podcast, it's about innovation in the agency space. And so we'd love to have you there. Um, all right. So let's take a step back and think about what does the term agency strategic alliance even mean? It's a term of art, everyone. It's not a term that has a specific legal definition to it. It is a term we evolved to at my firm to talk about these agency to agency collaborations when two agencies are combining forces for a common goal to serve a common client. Um, and the reason we don't use other verbiage that you might use in your day to day language, such as a strategic partnership, which is a very popular term to use, is that the term partnership has a very specific legal definition corporately, and it can imply some cross responsibility and legal risk that shouldn't really exist in these relationships. A partnership is a term with a very specific legal definition, which usually doesn't fit the relationships that we see with agency strategic alliances. And you might unintentionally be implying a legal affiliation that doesn't exist. That said, I understand that it's a term that gets bandied about a lot because it's got positive marketing connotations, and you're all marketers. So that's the reason why we don't use strategic partnership to define these relationships. I don't like the term subcontract because I don't think it really rises to the level of collaboration. Yet most agencies who combine their efforts have, at least in my experience. And it's not really an independent contractor agreement, although you can argue that the legal definition of the relationship between the parties is that similar to an independent contractor agreement, because you're usually talking about two businesses combining forces to serve a common interest or client. So again, term of art, it's the term we use at our firm to refer to these types of collaborations. We also see commonly three types of strategic alliance relationships, and I want to talk about those just very briefly. The learning here will be fast, guys. I'm going to go through it at a pretty fast clip so that we leave as much time for Q&A as possible, especially in light of the late start. But the three types of strategic alliances that we most commonly see in the agency world are, first of all, the referral, or what I like to call the preferred provider model. That I will go into detail about in a little bit. But it's usually the type of arrangement wherein the agencies are functioning independently, but there's a collaboration of goal or purpose. There is the teaming model where both agencies are at the table in concert with the client. And I'll go over that in a moment as well. And then there's the white label model, which most of you are very familiar with and usually think of in terms of web development talent or software development talent, but it works for lots of other things as well. And so that is where one agency definitely stays behind the scenes. So let's talk a minute about the referral or preferred provider model. This is usually an outright delegation from one agency to another of the work to be performed. It's typically you'll see it where agency one is really just looking to make a good fit for its client and build goodwill in the process, both with the client and with the other referred agency. Um, the lead agency will typically be the referred agency, and they'll charge what I call their rack rate fees, which means that they're not necessarily any discounting off of the market rates that the firm who's doing the work might charge. And there may or may not be either a reciprocal arrangement to refer business back and forth between the agencies, or sort of a right of first refusal. Or there may be some commission exchanging hands based on the amount of business that's exchanged. So that is the referral or the preferred provider model of a strategic alliance. Then we have what we call the teaming model. This is again where both agencies are client facing, but one is usually the lead agency in the eyes of the client, especially. But it's understood that they're sort of marshaling all the people together to reach a common goal for the client. Each agency tends to have very defined areas of responsibility. This may not always be completely clear to the client, so there's some communication that you have to do to make certain everybody's on the same page about that. The agencies in this case tend to have similar access to and insights into what the client's end goal is for the work that's being done, whether it's metrics to be achieved, whether it's goals for a campaign that goes out into the world. There's a lot less filtering of information between the lead agency to the strategic alliance agency that's brought on. And both agencies in this model tend to bill at their rack rates respectively. So it either will be a pass through for the lead agency in most cases, or there may even be some direct billing by both parties to the client. All right, white label model. This is where, as many of you know, and many of you maybe have experienced this, one agency is client facing and the other is in the background. And there is, there are ethical questions around the level of transparency you engage in about this with your client. And we're not going to get into those deeply, but it's up to you to decide how much disclosure is ethical disclosure about the fact that you are white labeling part of a piece of work to another agency who will work behind the scenes. Typically, full disclosure. Verges into a teaming arrangement versus a white label model, but there can be some overlap. So the white label agency that's brought in will typically have a very narrow swim lane. It's got specific projects, specific tasks, a specific area of expertise that is brought in to augment the more integrated work that the main or lead agency is doing for the client. The lead agency has access to the client's end goals, the business results that are expected to be achieved with the work, and it's not necessarily the case that they will tune the strategic alliance agency, the white labeled agency, into all of them. I happen to think candor and transparency between the agencies and the collaboration is helpful, but we see varying degrees of it, honestly. This feels much like, or most like, out of the three models, like a subcontract relationship. Again, I don't like the term in this context because I don't think it elevates the parties' collaboration fairly, but there's usually an accommodation in the pricing of the white labeled agency. So that will enable them, the lead agency, to pass work through at least with enough margin to cover administrative costs of working with the white label agency. Sometimes there's a little bit of margin left on the table, although we all know in the agency world, margins are tight anyway. And so this is usually less about making margin off of the white label agency's work, although it is possible in many cases. It's usually more about filling a specific need to do a specific type of work to integrate into the agency's other work for the client. How do you know which model makes sense? I got a couple situations here to run by you, and you'll recognize yourself, your agency's situation in one of these, with my best estimate of which arrangement makes the most sense under the fact pattern. So, do the agencies offer similar services to other clients, or at least one of the agencies highly specialized? In that case, a white label relationship is probably going to make the most sense for the two agencies involved. Do both agencies work in similar client industries? In that case, white labeling is usually super important because both parties are concerned about exposing their client rosters to other agencies who could be competitive with theirs. So white labeling tends to make
to checkbooks for
we got someone who needs to mute themselves.
Sharon, you're muted now.
Thanks, Hannah. All right. So, will it affect the quality or the timing of the deliverables to keep one agency behind the scenes? If that's the case, that's usually not a good position to put yourself in with the client. And so, teaming probably makes the most sense where there's real time access to all parties working on the project, to all the key stakeholders within the client organization. I say that with a grain of salt because I know that in all cases, the lead agency wants to be in control of those communications. So you've got to work that out in the conversations you have with one another before the work starts. And I'll talk about that in a moment. Do you have similar working styles and working cultures? In that case, teaming probably makes really good sense for you. Do you want to just maintain a relationship with a client on an ongoing basis for the types of work that you like to do, and then maintain goodwill relationships with really well vetted specialists, um, so that there's goodwill all around, and then possibly the opportunity to earn a little bit of commission? In that case, the referral relationship probably suits your goals the best. All right, we're going to talk about crucial conversations related to strategic alliances, and then we will talk about critical contracts. That will be the bulk of the rest of our discussion, and then we'll open it up for your questions. All right. So, crucial conversations in a strategic alliance between agencies, um, each should most likely be reflected in an appropriate contract and a clause in your agreements with one another. And we'll go through those. Um, your agency's strategic alliance agreements, you should consider them if this is going to be part of your business model ongoing. You should consider them one of your agency's foundational legal contracts. This is, I think, our fifth or sixth Q&A session since we started doing these. We do them quarterly, and at each we've sort of talked about the idea of the foundational legal agreements: your master service agreement, your statement of work templates, your independent contractor agreements, employee agreements. Some of you need a good inventory of side agreements based on your discipline at your agency. Might be IP licenses, data protection, influencer marketing agreements. You all need a foundational toolkit. And if you're going to engage in strategic alliances regularly, then strategic alliance agreements need to be a part of that toolkit. Let's talk about the conversations that you need to have, each of which need to be reflected in the appropriate strategic alliance agreement. Confidentiality. This is critical for lots of reasons. As to the client, what is their business strategy? What are their product and service introduction plans? Highly sensitive in many cases, highly confidential information belonging to the client. As the lead agency, you are likely subject to confidentiality covenants with the client, and those are expected to carry through to your strategic alliance collaborator. So that needs to be part of the conversation before work ever starts. What about the agency's information? First of all, the client identity. That is part of a client list that is absolutely a trade secret of each of the agencies who are listening today. And so you need to be careful about safeguarding that information before you share it. So the client's identity, absolutely part of the confidentiality discussions. Any proprietary methods or procedures or systems that either of you are bringing to the work should be part of the confidentiality understanding between the two of you. If the strategic alliance firm that's being brought in has particular competence in a skill or a technology, or they have a methodology for assessing something like brand opportunities, whatever it might be, if you consider it your secret sauce, if it's proprietary to your agency, then confidentiality around it needs to be part of the relationship and reflected in your agreement. And then things like strategy recommendations in your planning tools and documents. I think that falls under the purview of methodologies and systems as well. All right, the second crucial conversation, and you'll see the quotation around the term ownership, because we all know ownership of any client relationship is this beautiful fiction that only stays relevant for as long as the relationship with the client stays happy, healthy, etc. And there are lots of reasons clients move on from agencies. So when I use the term ownership, I'm not using it sort of in a fantasy land sort of a way. I'm using it in terms of the parameters of your existing ownership relationship with the client at the time you engage a strategic alliance firm. So, who will communicate directly with the end client? Will it just be the lead agency or might it be both agencies? Who handles invoicing and who sets pricing with the end client? What are the swim lanes or the areas of responsibility for each agency? Will one agency only weigh in on web development, software development, brand strategy? Whatever they are, define them and include that definition in your agreements with each other. Liability to the client. I'm going to put a pin in this for a second because it's a crucial conversation all of its own. But you need to be thinking about what expectations do you have of one another, of who's responsible to the client if something goes sideways in in the work of the project. And pitching additional work to the client. This is a super sensitive topic with agencies who get into business with other agencies to serve a common end client. Uh, what if there's opportunities to offer additional work or services to that client? Are there restrictions around that? What is the understanding? Is it okay? Do both parties have equal access? Does the lead agency want the strategic alliance agency to agree not to do that for a period of time? Can be very sensitive conversations, but there's things you need to talk about. The sooner the better. And some of them won't emerge until you've already been working together with the client. That's understandable, but they should be discussed as soon as they're sensed as a potential hot button issue. All right, I'm an IP lawyer by training. It's my first love, and so I'm going to talk about IP. Um, who has the right to use the proprietary intellectual property that, let's say, a strategic alliance agency is bringing to the table? In many cases, your relationships are going to have to be augmented with license arrangements. Let's say the strategic alliance firm has its own software or it has its own content library, whatever it might be, and they're not giving it to the end client, they're licensing it to you and to the client. Does the client know that? Do the provisions in the agency's agreements with each other mirror what the lead agency has promised to the client in terms of ownership of the final work product? It's important to have that conversation, and thinking about it late in the game is not going to be a good result for anybody. And at the minimum, it's going to slow the work down. So talk about it early and often. All right, capacity and service levels. I think most agencies intuitively understand that this is something that has to be discussed early because the client will be pretty forthcoming in the beginning about what deadlines that is expecting, what the deliverables should look like. And so you need to know, as a lead agency bringing a strategic alliance firm in, what is your expected turnaround time for getting this work done? Can you turn it around to us in a manner that will allow us to meet our obligations to the client? Again, it's that waterfall that needs to be in place between the client contract and the agency to agency agreement. What work guarantees or warranties are being made? If you've engaged a strategic alliance firm to do a web development project, are they going to stand behind that work? And I hope they are. And if so, for how long? And what will be the protocol for debugging and sorting out any problems that occur? Access to key personnel. How quickly will you be able to get access to the other agency's team if you need their insight, their expertise, or some sort of correction made? And what are the communications and reporting protocols going to be between you? Will you meet regularly? Will there be reports due at a regular time? Best to hammer all this out in the beginning so that nothing hampers the ability of the client to get the information it needs from the lead agency in a timing that it considers reasonable. All right, crucial conversation 5. This comes up all the time. We'll get a call from a lead agency. This comes up with independent contractors and freelancers too, by the way. So and so agency or so and so freelancer has put our client's brand up on their portfolio website. We don't even have permission to do that. And they're doing it, first of all, in violation of our agreement. And second of all, in a way that makes it look like the client is their client and that we've got nothing to do with the relationship. Lots of hurt feelings, lots of misunderstandings. So hammer this out up front. This is, again, a cross reference with the confidentiality and client ownership and air quotes discussion. Which parties can display the names of the end client? What does the client contract say about that? Which parties are able to display either case studies or examples of the work? on their own sites. And what does the client agreement say about that point? So you need to have that conversation up front. Exclusivity. I'm going to get through this one really quickly because I'm going to say almost in no case will that I know of will any agency in a collaboration with another agency want to take on an exclusivity obligation. But it is if the opportunity with the client is big enough and the client, that the lead agency has agreed to accept that exclusivity, it's going to want to work with other agencies who will agree to the same limitations. So you have to really think about it carefully, in light of your own business goals if you're going to enter into one of these collaborations and see if it's a trade off you're willing to make for the opportunity. But you think about exclusivity restrictions in terms of geography, product or service category, the industry overall, or even a particular company or a company division. Sometimes we've seen situations where agency A works with division A of an enterprise size company, and agency B might have an opportunity with division D of that same company. What happens then? You need to talk about that up front. All right, liability and indemnification. Who's responsible for guaranteeing the quality, performance, accuracy of the work to the client? And does that liability waterfall down to the strategic liability agency? And issues like non performance, infringement, mistakes, errors, and omissions are things that need to be considered what would happen if they occurred. All right, so critical contracts for agency strategic alliances. Again, part of the agency foundational legal agreement toolkit. Here's the list again, one more time, just to remind you of the things you should be thinking about having in your inventory. But let's talk specifically about the critical contracts for the alliances themselves. The first thing you should have in your toolkit, a mutual non-disclosure agreement to use in agency to agency discussions. This should be ready in advance of you ever doing work or signing an agreement to do work with another strategic alliance collaborator. Why? There may be situations where you need to bring them into new business pitches. You may need to give them access to your proposal for the client so that they can give you a quote for what their part of the work might cost. They may need to help you actually create the pitch deck or create the response to an RFP. And you're plain old disclosing potential opportunities or strategies to them, even by asking them to potentially sit at the table with you or be a participant in the project. You need an NDA to cover all of that stuff, and it should be mutual between the agencies. This is different from having an NDA to use for a potential client relationship or some other sort of contractor or vendor, because you're both in the agency world and you're both bringing original contributions to the table. So NDA, agency to agency. Critical contract number 2 is the actual agency strategic alliance agreement. You may need all three types. You may need agreements for all three types, depending upon how many ways and times you collaborate. But you should have a version specific for a plain referral relationship, a teaming relationship, a white label relationship. And I'm not going to say that these are 100% distinguishable from one another. There is some redundancy in some of these, but they each should be drafted with the particular type of relationship that you envision in mind. And you need to nail all those terms down in writing before work begins. I will say this that I see commonly attempts to shoehorn agency to agency strategic alliances into either an MSA template that one agency uses or sometimes into an independent contractor agreement that's better suited for a single freelancer. They're not the same. Doing that usually means you're going to omit some important information or important conversations. So I'd encourage you, if this is going to be part of your business plan to enter into these alliances, have specific contracts tailored around that. All right, the statement of work. This is very similar to how you think about the work that you will quote to a client. Everybody's familiar with the SOW. Remember that this is where you put your deliverables. What's the work going to be? Your dollars. How much is it going to cost? And what are the payment terms? And your deadlines. By when? And when do we talk? When is the work due? Etc. This kind of stuff is more suited for putting in the SOW than in the actual strategic alliance agreement itself. Again, make sure the SOW here aligns with whatever you've committed to the client in your SOW with them. All right, I've talked a lot. I've talked quickly. Um, but now you're thinking to yourself, this is all great information. This is nice and academic, but what do we do now? What does our agency do now? Well, we got a few things to help you. First of all, you're going to get the recording of this session, including all the Q&A that's upcoming. Share it with your team. Share it with your account team in particular, if they're the ones who are looking for these opportunities and making the deals with other agencies, and help them understand what some of the issues might be and some of the conversations that they might have will be. Next, you've got a QR code that'll take you to our agency resource center, which has got content specific to agency strategic alliances, including a free checklist and some other content as well. And then stay tuned because we'll be following up with you with some more information that can help you um, move down this path with more confidence and more success. So with that, I want to say thank you for hanging in there for the extra minutes it took us to get this off the ground, and also for expressing interest in doing this with forethought and being proactive about how you engage in these relationships, because it will definitely save some friction, some time, and some money down the road to be armed with this kind of information if this will be part of your business strategy. Again, that QR code goes to our resource center, which has got some free tools there. And now, Hannah, I'm going to shut up and take some questions.
Okay, we have quite a few. So I'm just going to kind of go down the list of what I've seen so far. And if I miss anybody, please feel free to interrupt
I'm
me. So
ready.
first question is Vari Wonder. She's in Canada. She said, wondering if this is US centric content or if it applies to Canada and Canadian relationships as well.
I think it applies globally. Of course, there may be national law differences in terms of provisions that you may also need to add into the agreement. And depending on the scope of the work being done, there may be specific things you have to include. For example, if the work involves a lot of data handling, if it's influencer marketing where there's regulatory considerations over the content itself. So there might be some extra things that are special to your jurisdiction, but the principles regarding the crucial conversations and the actual tool set that you need to have, I think, to engage in this strategy while limiting your risk, I think are the same. I think they're universal no matter what state you're in the US, or even if you're a Canadian agency.
Awesome. Thank you, Sharon. Okay. Next question. Henry is wanting to know what the best policy is for AI in the agreement. So Henry, if you're able to chime in here, great. But I think in terms of this conversation, are you talking about if, one or both of the agency partners are using AI, and how does that work? Is that kind of what the question is?
That's it. I've been reading online all different things about what you should put in, that why you're asking and what you're asking. Since Sharon mentioned that's something she was concerned about, I'd love to hear her thoughts on it.
Yeah, it's a great question, Henry. And I think just like AI needs to be addressed in an agency's contract with its client, um, I'm all for addressing AI in the actual agency to agency agreement as well. Whether you do it in an addendum or whether you do it in the body of the agreement, which is our preferred approach, um, you need to know if your strategic alliance firm is using artificial intelligence to generate work product. If they are, you need to know what tools do they use, what are the use cases for them. I mean, are they using it just for inspiration? Are they using it to create first drafts? Are they using it for strategy development? And you need to have a crucial conversation with them. I should have added this to crucial conversations about what your client's policies and restrictions are around the use of AI, because I will tell you, agencies are miles ahead of your typical enterprise size client or government agency client in terms of their understanding of the possibilities of using generative AI in content creation or in other work creation. And so, if because of that, your client is way behind where you are, maybe they don't want you using generative AI at all, in which case you need to disclose that to your strategic alliance agency and help them understand it and put that understanding in writing in the agreement. So I'm super glad you brought that up because, yeah, I think it's increasingly going to be a mandatory thing to address in the agency to agency agreements themselves. As a matter of fact, our strategic alliance agreements have all been updated to include AI generation um, in their terms. So thank you for asking that.
My pleasure. And it's a changing, probably in 3 months from now, it's a different answer.
That anything is possible with AI. We're keeping our thumb on it as best as we can, but it is it's moving at a pace that's faster than most of us can keep up in real time. So we lawyers are just doing our best to clean up after all of you marketers.
The
Thank you.
full-time job. Okay. Next question. How specific do the agreements need to be? Is it a per client basis or is there an overarching agreement that you can rinse and reuse?
I think there are similarities and redundancies between the agreements potentially depending upon the types of relationships you see yourself as an agency entering into. I think the teaming and the white label um, agreements between agencies have more redundancy between them than either of them have with the referral version of a strategic alliance agreement. So, can one size fit all? You just need to make sure that if you're using a very general um, model document, that it is customized for each specific engagement. And so, we advocate versions for all three of the types of arrangements. Your agency may only need one or two of those. It just depends on how you best collaborate with other agencies.
Perfect. Okay. And then Sandy asked, are you able to explain a little bit about one of these agency strategic alliances versus independent contractors? We work with several solo practitioners.
The solo practitioner is really, there are legal concepts that are redundant to both types of relationships, Sandy. So, you know, liability for content originality, liability for work done improperly. A lot of these things should be addressed in your standard independent contractor agreement with freelancers. I think the heightened level of expectation, though, when you're collaborating with another agency is that there is more of a peer-to-peer relationship between the organizations, which is why I don't like to see a freelancer agreement shoehorned for this type of relationship because um, you're, I think, both taking on a more level amount of risk than a typical freelancer would be. And typically, the involvement of a strategic alliance agency in serving the client's needs is going to be deeper, broader, a little more expensive than the investment in an independent contractor who is freelancing for very specific projects. Those are general statements. Your mileage may vary. It's not true of every situation, but it is the reason why we view the relationship types differently, even though there are legal concepts that are very similar or redundant in both kinds of relationships, freelance and strategic alliance.
Okay. And then Katie had kind of a follow on to that question. Does it matter if the independent contractor is an LLC or S Corp versus just themselves operating under their personal social security number?
Right. Well, that's more of an independent contractor question, but I would love to answer it because the way laws are evolving right now, particularly Katie in New York, I know you've got some recent law changes there. I would counsel anybody working with a freelancer to try to require them to be an LLC or an S corporation so that it's an entity to entity agreement. I mean, there are certain states. Henry and I had this conversation a couple days ago about California. New York is certainly evolving, and many other states will follow them in terms of being more likely to classify an independent contractor as an employee than as an independent contractor, which is not a situation that you want. Otherwise, you'd be employing these individuals. So, having entity to entity transactions um, takes one of those preventative steps from misclassification of the individual as an employee. So, but we're talking again, though, about single member LLCs or single owner corporations versus a strategic alliance, which tends to be a more business to business relationship. But the short answer is yes. Ask your freelancers to form entities and put contracts in place between your agency and their entity, to create some more distance and a more arm's length relationship between the two of you to help avoid that misclassification whenever you can.
Okay, awesome. The next question is from Erica. She said, we have a white label IC who did the work to help us win many awards for a client, as well as support us for a nomination for PRSA Anvil. We find out if we win in a few weeks. So, okay, for that, Erica. Good luck. Meanwhile, she is asking to promote the nomination and win on her end. She would position it as her company in partnership with our agency. We feel a way about this, as in reality, we are her client. Other peers in our industry feel this IC should be able to promote as this is her work too. Thoughts?
Oh, Erica. So I tend to be an IP purist about this a lot, and I understand that sometimes that view has to be stretched around a little bit because of the way that the industry works. So my response to that is if you created it, if it's yours and you contributed it in a white label fashion, I think it's your say. And I think it's a perfectly reasonable position to take, whether or not you want it submitted at all, or whether you want to make it a joint submission and have both companies referenced. Um, I feel your pain. I understand. I understand the dilemma that you're in, and I too feel a certain way about it. The purist in me says not unless we can make a deal about what that application actually looks like, and we accept and apply for the award together. Um, if you're even inclined to do that at all, but I think it's your call.
Okay, awesome. Next question. Why should agencies include rules in their partnership agreements to ensure their work stays unique and original? Would specifying who owns the creative work, the rights to it, and following brand guidelines help avoid disagreements over creative integrity?
I think I need you to read that again, Hannah.
Yep. Okay. So this person says, why should agencies include rules in their partnership agreements to ensure their work stays unique and original? Would specifying who owns the creative work, the rights to it, and following brand guidelines help avoid disagreements over creative integrity?
I think it does help avoid disagreements because it forces the conversation to occur sooner rather than later. I also think in some cases you can't overpaper this issue. Not only should there be provisions in the strategic alliance agreement about each party owning its own respective IP that it's contributing, but you may have to also include specific language in a statement of work about it if there are parts of the work that you're going to do that are truly considered works for hire and the client is you're okay with the client owning them, but there are other parts of the work that involve using your pre-existing IP that you're only licensing that to them. So I think it should always be discussed. I think it should always be reflected in the strategic alliance agreement terms. And I think there's some cases where you need to sort of belt and suspender it in your statement of work, depending upon how broad the work scope is and whether there's multiple components of it, where you might have different positions on IP related to those segments.
Okay.
And the goal here, I just want to say, the goal here is not to have to overpaper this or to use these tools in an obstructionist way. I mean, we agencies want to collaborate as quickly and as easily as possible, which is why I'm an advocate for thinking about these things earlier so that you're not slowing things down by hammering them out later. I'm also not a fan of, contracts for the sake of contracts, but I think we've seen enough situations at our firm where the contract exercise wasn't engaged in, and if it had been, it would have been an exercise in these discussions, and issues would have been cleared up sooner rather than later. So I think they're important.
Okay. Next question that's kind of a follow-on to that. Is it crucial to understand how agencies manage their files and artwork, especially considering some clients may have specific requirements, such as not using Google Shared Drive? Can such preferences be outlined and included in the agreements between agencies?
I think so. I think those are specific parameters that probably end up best expressed in the SOW because they may not apply to every single project that the parties collaborate on. But if they rise to the level of importance that the parties want to include them in the main body of the strategic alliance agreement, I could make a case for that because that is definitely um, there are confidentiality, data privacy, and other issues that might be invoked by the client's insistence on that protocol. So it could be elevated to the agreement. It definitely should, at a minimum, be addressed in the statement of work where you're describing the services and the communication protocols.
Awesome. I love that you said I could make a case for that because that's so lawyerly of you. I love it.
Sometimes I can't help it.
Okay, next question is how do you deal with contractors or alliances producing work using licenses such as graphics, video, etc., that are different than the ones your company uses to produce work?
Oh, what a mess. I have evolved my position on using licensed assets like from stock houses and things like that. I have evolved to the point where my preferred approach is to simply have the client establish accounts and give the agencies administrative access to them. I just think it makes it so much clearer to understand what types of licenses you are purchasing, to not have to deal with the pass through issues associated with that. Um, so I think you need to have to specifically answer this question, I think you need to have a very clear conversation about what third party assets might be needed to complete the work scope. I think you need to have a very specific, like, pre-production meeting and put this in the statement of work. Um, you need to have a very specific meeting wherein you actually talk about the types of licenses that are expected and what the use cases are going to be for the third party assets so that you're not caught short cheated or your client or in a bad conversation with your client because your strategic alliance agency didn't have the right permissions or licenses to meet the campaign goals. So it's an early discussion you need to have before work gets done. It's a verification process that the parties need to take time to do. And if you can at all help it, um, getting the accounts established in the client's name. Not every agency loves this. Some agencies choose to mark up some of this third party work. Some agencies want the control of, picking and choosing which licenses for which projects, etc. So it's proceed at your own risk and use the approach that works best for you. But it is definitely a conversation, and if it is needs to be elevated to a point where it has to be put in writing, then the SOW would be the place to do it.
Awesome. Okay. And then I believe this is the last question in chat. When is it appropriate to start the conversation around agreements, right away or after the client signs? So if you could advise on when to start these conversations around agreements, that would be helpful.
I think it depends upon how much you know about the work scope and the potential relationship with the client before you know you need to engage a strategic alliance firm. And what I mean by that is if you need a strategic alliance firm's participation in actually pitching for the work or proposing for the work, then you need the NDA immediately. That's the contract that you really need up front. And then before any work is planned, before any kickoff meeting occurs with the client, that's when you need to have the conversations and document the relationship in the appropriate strategic alliance agreement. Do it before any work starts. And, you know, it can seem like a bit of a waste of time and money to enter into the strategic alliance agreement before you even know if you have the client work yet. And I can't think of an agency in our client roster who would be happy about in making that investment, quite honestly. But at a minimum, you need that NDA in place so that those details are tight and secure. Um, and you need to discuss client ownership, air quotes, before you pitch together or propose together, because that could lead to some significant misunderstandings if you don't have that conversation up front.
Awesome. Okay, Sharon, I don't see any other questions in chat. There's been a lot of people that have obviously thanked you for sharing your smarts. So thank you so much for helping us navigate agency to agency alliances. I know that's something that we can all benefit from, but I know that can also put us at risk if we don't navigate those properly. So thank you for sharing your smarts today. And guys, thank you all for spending time with us despite the technical difficulties. We really appreciate your time.
Yeah, we appreciate you hanging out till the end too. That means a lot to us. And so reach out if we can be of any help, and we'll be in touch with some follow up as well. So thanks, everybody, and have a great afternoon. Good to see you all.
Thank you guys.